everyone, IS. Today we will be discussing editorials from the Hindu of 17th of November 2022. So let's start with the day. Unsetting of Vice-chancellor, is it faulty? You can relate this topic with your General Studies Paper 2 syllabus. I have not written the complete topic, but I have only mentioned the keywords here that you can relate this topic with the federalism, that is the balance of power between the center and the state's government, the state legislature, the acts which are enacted by the state legislature and what is the territory in which those acts are implementable, and the position of the governor. Now, these three things are very important when we speak of the position of the vice chancellor and recent controversy with respect to the order that has been sent by the Supreme Court to basically quash the appointment of vice chancellor because it has not been done according to the UGC regulation of 2018. So these three things we are going to discuss in this topic, and we would also see what were the UGC regulations of the year 2018 and how they mandated the appointment of the vice chancellor through the search cum selection committee, and what were the other regulations that were mandated by the UGC. What is UGC basically? And we would also discuss the role of the vice chancellor, and we would also discuss in brief that what is the role that the government has to play when it comes to the appointment of the vice chancellor of the body, and what is the role of the governor basically as the chancellor of the state universities or the central universities. So this is the article which I have taken from The Hindu, and this article has been written by P.D.T. Acharya, who was the former Secretary General of Lok Sabha. And we would discuss this article from the perspective of the writer. We would only include the view of the writers and what the writer has to say. And if there is any static topic that comes in between while discussing the editorial, I have included that too. So that this topic is comprehensively covered for your examination, especially for the General Studies Paper 2. Now let us discuss what is the recent context of this article. Now, recently there were two judgments that were given by the Supreme Court on the appointment of the vice chancellors in the state universities, which were, according to the Supreme Court, are in violations of the regulations of the UGC, which is a statutory body under the UGC Act of 1956, and are significant in the context of the higher education in a federal country such as India. So there are certain keywords in this paragraph. The first one is the Supreme Court intervention. Supreme Court intervention. That means the Supreme Court has the power to pass an order when it comes to a federal issue. That means the issue which is between the center and the state. The second point is the state universities. State universities. That means the state universities are to be governed by the UGC regulation, and UGC is a statutory body. However, it is to be noted that in the subsequent editorial discussion, we would also be discussing that state universities are universities which have been established by a statute. That means a state legislature must have passed an act for their establishment and for their functioning and the governance, which is the State Act. So there is a sort of controversy whether the appointment of the vice chancellor has to be done by the UGC regulation or by the State Act. All right. Now the third keyword here is the education. Now education, according to the 7th schedule, which has basically demarcated the subjects between the center and the state, and there are concurrent subjects and there are residuary subjects. So the union subjects are dealt with by the union government, and the state subjects are dealt by the state governments. However, there are list of the subjects in which both the union and the state government has the right to form the legislation. That means the statute or the law, rules and regulation. And education is that one subject which is in the concurrent list. That means the parliament as well as the state legislature has the right to pass an act with respect to the education in the country and with respect to the education in the state. Now the fourth key word here is the federal country. By federal means that the subjects, not only the subjects have been divided, but also the power has been divided. According to Article 1 of the Indian Constitution, India is a union of a state. Right, an Indian union of a state is indestructible. That means the state can be destructed. That means there is a provision under Article 3 and 4 and Article 2, 3, 4 that the states can be redesigned, their boundary can be changed, their name can be changed. However, the union of the India that is represented by the states, by the union of the state, is indestructible, because no Indian state has the right to secede from the union of the state, that is India, Bharat, according to Article 1. Now we have discussed the keywords here in this paragraph. Now let us move on to discussing the context. Now the first case is the state of Gujarat, that is Gambhir Dhan K Gadhvi versus the state of Gujarat. This person Gambhir Dhan K Gadhvi was the Vice-chancellor of the University of Gujarat, which is Sardar Patel University, Gujarat. The court, which was headed by Justice M.R. Shah and Justice B.V. Nagaratna, these are the two persons. I have put their pictures so that you can recognize them. So the bench, which was headed by the two judges bench, which was headed by M.R. Shah, Justice M.R. Shah and Justice B.V. Nagaratna, quashed the appointment of the incumbent Vice-chancellor on the ground that the search committee did not form a panel for the appointment of the Vice-chancellor. We would discuss the UGC regulation 2018, that what is this search selection committee and what is the panel that is formed according to this regulation, which further leads to the recommendation of the name that are to be appointed as the Vice-chancellor, and finally how the Vice-chancellor is appointed by the governor. Okay, so the governor acts as the chancellor of the university and governor further appoints the Vice-chancellor of the university. So according to the Supreme Court, according to the two judges bench headed by Justice M.R. Shah and Justice B.V. Nagaratna, the Sardar Patel University of Gujarat had not formed a panel for the appointment of VC, right? And therefore, this was not in accordance with the UGC regulation of 2018. Therefore, the appointment of the Vice-chancellor of the Sardar Patel University is held as invalid, right? So it was held that since the state law was repugnant to the UGC regulation, the latter would prevail and the appointment under the state law had become void ab initio. Now this term ab initio means since the beginning when the law was formed. So this is what the ab initio means. So what does the court had to say? If I simplify these three lines in simple words, is this: that the state law is subordinate to the UGC regulation and the UGC regulation would prevail when it comes to the appointment of the Vice-chancellor, and thus the appointment of the Vice-chancellor according to the state law, it has become void ab initio. That means since the beginning, since the time the law was formed, since that time the Vice-chancellor's appointment has become invalid, it has become void. So this is the first case. So we have understood the context, the first context that the writer has given. Now let's talk about the second context which the writer has given. The second context is from the state of Kerala. Now recently, if you have noticed that there has been a tussle between the state governor, which is Arif Muhammad Khan, and the state government, which is headed by the chief minister. Now the point here is that the state government, the council of chief minister, the chief minister and its council had asked the governor to pass an ordinance for the removal of the governor as the chancellor of the university, according to the recommendation of the Punshi committee that was established in the year 2007. Now this was the stance of the state government of the Kerala, that if the governor does not passes an ordinance for its removal as the chancellor of the university, then the state government is going to bring a bill in which the governor will no more be the chancellor of the state university. So this is what the stance of the state government of Kerala is. Now After the passage of these two, after the passage of this judgment by the Supreme Court, the first judgment, the two judge bench headed by Justice M.R. Shah and Justice B.V. Nagaratna. So according after this judgment, according to the governor of Kerala, the rest of the vice chancellors who have not been appointed as per the UGC regulation should resign. So far, none of the vice chancellors who have been given order for the resignation has not resigned. So this is the first case now we've discussed. All right. Now we are going to discuss the second case. The second case from the state of Kerala is the Professor Dr. Srijit P.S. versus Dr. Rajashri M.S. This was the judgment on October 21st, 2022, with the bench of Justice M.R. Shah and Justice M.M. Sundaresh. The appointment of the Vice Chancellors of the APJ Abdul Kalam Technological University, Thiruvananthapuram, was challenged on the ground that the search committee recommended only one name, which is against the UGC regulation. Now, what is the point here? See, whenever there is a search cum selection committee, they have to give plurality of the names. That means more than one name is given, more than one suitable candidate is recommended for the post of vice chancellor, and then it is the prerogative of the appointing authority that who the appointing authority considers as the best fit for the position. So in this judgment, the Justice M.R. Shah and Justice M.M. Sundaresh, they have given this judgment that the search committee had recommended only one name, right, which is against the UGC regulation. So therefore, the appointment of the Kerala Vice Chancellor of the University APJ Abdul Kalam Technological University, Thiruvananthapuram, has been invalid. It is void, So the challenge succeeded and the court quashed the appointment of Vice Chancellor on the ground that the provision relating to the search committee in the University Act is repugnant to the UGC regulation and was therefore void. Now, after these two judgments, what I could conclude is that the UGC regulation are held superior to the state law. Whether it is the university in the Gujarat or it is the university in the Kerala, right? So this is according to the judgment. Now let us discuss in briefly the UGC regulation. See, according to the University Grant Commission Regulation 2018, the Vice Chancellor of a university in general is appointed by the visitor or the Chancellor from a panel of 3 to 5 names recommended. Now you remember in the second case, Justice M.R. Shah and Justice M.M. Sundaresh said that the search cum selection panel had recommended only one name. But however, according to the UGC regulation, 3 to 5 names are to be recommended by the duly constituted. Duly constituted means something which has been established as per the law. Here, in case the regulation of UGC 2018, search cum selection committee. The visitor is then empowered to call for a set of fresh names in case of dissatisfaction with the given panel. That means the visitor has the authority that he or she can call for the fresh names if he or she is not satisfied with the names given by the search cum selection panel. All right. Now, in universities, the President of India is the ex officio visitor of all the central universities, not the state university, because in state university, governor acts as the chancellor and of the respective state university. Now this is a very clear cut difference, that president is basically the visitor, or you can say the ex officio visitor of all the central universities, not the state universities, because in state university it is the governor who acts as the chancellor. Right. So we've understood the regulation now. We've understood the position of the president and governor with respect to the universities, right? And in which universities they are to be appointed as the visitor or the chancellor respectively, Right. Now, what is the role of the chancellor? We will continue with the article, but this is something which I thought would be important for in order to understand the article completely. Now we have understood the UGC regulation, that this was the main point of the UGC regulation 2018, due to which the appointment of the two vice chancellors of the University of State University of Gujarat and Kerala has been quashed according as per the judgment given by the Supreme Court, headed by two judges bench respectively. So far we've discussed the UGC regulation, the main point of the UGC regulation under which the judgment of the Supreme Court has quashed the appointment of the vice chancellors of the university. And now let us move on to the role of the vice chancellor. Now basically vice chancellor, he or she, they act as the principal academic and the executive officer of the universities. They are expected to function as the bridge between the executive and the academic wing, and their role is expected to facilitate that always the person with high integrity and values and personal characteristics of and the academic excellence and administrative experience are they get associated with the university. And there are many commissions and the committee who have highlighted the importance of the role of the Vice Chancellor in maintaining the quality and the relevance of the universities, in addition to its growth and development, keeping in view the much needed changes from time to time. The Vice Chancellor of the universities is also the ex officio chairman of the court, the executive council, the academic council, the finance committee and the selection committee, and shall, in the absence of the chancellor, preside at any convocation of the university for conferring the degrees. The other duty of the Vice Chancellor is to see that the provisions of the Act, either the Central Act or the State Act, statutes, the regulations and the ordinance, they are fully observed, and he or she should have the power necessary for the discharge of his duty. Now, after the passage of these two judgments by the Supreme Court, what is going to be the consequences? Basically, the decision of the Supreme Court, it has triggered an unprecedented developments in the state of Kerala, with the state governor Arif Muhammad Khan, who is the chancellor of all the universities in the Kerala, because according to the Constitution of India, the governor has the power and his position is that of the chancellor of the universities in the state, and visitor of Central University is the President of India. So therefore the governor of Kerala has asked as many as 11 vice chancellors of other universities of the state to resign immediately on the grounds that their appointment had become void after the passage of this judgment by the Supreme Court, the two cases that we discussed earlier. Now, the case is before the Kerala High Court that none of the vice chancellor has resigned as per the directions of the governor. This has further intensified an already raging battle between the left Democratic Front government of the Kerala and the governor, and it is likely to become even more fiercer if the Kerala High Court quashes the appointment of the vice chancellors of the Kerala University of Fisheries and Ocean Studies on November 14th. And this has already been done, and this tussle between the governor and the state chief minister and his council, it has become even more fierce, that the appointment of the vice chancellor, it stands in violation with the UGC regulation, which we discussed earlier. Now we will discuss that what is the core issue. We are talking about the UGC regulation of 2018. We are also talking about the state university and the state law under which the universities are established. In both these cases, the core issue that has been framed by the Supreme Court is that the appointment of the vice chancellor has to be made as per the UGC regulation. The question is whether the UGC regulation should prevail or the provisions of the State Universities Act. In a federal system, according to the writer, the framing of such a question by the court may look strange, but under the Indian Constitution, both the union and the state can legislate a matter under the concurrent list, and education is a concurrent list matter. As education is a subject on the concurrent list, this question needs to be addressed seriously, whether it is the UGC regulation that is going to prevail or it is the State University Act. So a vice chancellor who is appointed by the chancellor, the vice chancellor is appointed by the chancellor. That means the governor appoints the VC under the relevant University Act. But the Supreme Court has brought into light Article 254 of the question, which says that the state law are repugnant to the provisions of the union law, and if there is a conflict between the union law and the state law, the union law shall prevail. So this is what the Article 254 says. Now the writer is of the opinion that whether we consider the rules and regulations whether we consider the rules and regulation as law for the purpose of Article 13 of the Indian Constitution, as law for the purpose of Article 13 of the Indian Constitution. Now Article 13, if you have read Lakshmikant, it is clearly mentioned that Article 13 deals with the law. It gives the definition of the law, and Article 13 has given a wider definition of the law. However, for the purpose of Article 254, when we speak of the rules and regulations which are made by a statutory body, are going to be considered as law for the purpose of Article 13. So it is to be seen. So there are two issues now. The language of the Article 254, Article 13, which talks about the law, which gives the definition of the law for the purpose of Part 3rd of the Constitution. That means from Article 12 of the Constitution till Article 35, which deals with the fundamental rights for the citizen, fundamental rights that are enshrined in the Constitution of India. So for the purpose of Part 3rd of the Constitution, Article 13 gives the definition of the law. Now according to the writer, it is to be seen, listen carefully, according to the writer, it is to be seen whether Article 13 is valid for Article 254 or not. That means the rules and regulations which are designed by the UGC, which is a statutory body, should stand superior to the state law or not. So the question is that whether the UGC regulations stand superior to the or superordinate to the State University Act, right? Where education is a in concurrent list, and education is a matter or is a subject on which the union as well as the state government can form law, right? So, in the cases which are mentioned above, the top court found that the search committee recommended only one name. However, in the UGC regulation of the year 2018, we saw that two or more names shall be given. That means the plurality of the names has to be given by the search and search cum selection panel for the appointment of the vice chancellors of the university. So, according to the UGC regulation, 3 to 5 names are to be given. Therefore, according to the UGC regulation, the appointment will be invalid, right? Therefore, the court's conclusion is that if any provision in the state university law is repugnant to the UGC regulation, the latter will prevail and the former will be void. So, on one side, we have an act which is passed by the legislature, and on the other side, we have regulations which are made by the subordinate body such as the UGC, which is a statutory body according to the UGC Act 1956. I hope so far this issue is clear to you now. So let's move on in the editorial further. The court has concluded that the provisions of the State Universities Act are repugnant to the UGC regulation under the Article 254 is faulty. This is according to the writer. So now we are talking about the writer's opinion. So whether the conclusion which is made by or the core issue which is highlighted by the Supreme Court of India is faulty or not. So according to the writer, the issue is faulty because according to the writer, we cannot consider the law which is passed by the state university as subordinate to the regulation which is made by a statutory body such as UGC. This is what the opinion of the writer is. So writer has given 3 reasons for that how and why this conclusion by the Supreme Court and the benches headed by Justice M.R. Shah and M.M. Sundaresh and a bench which is headed by Justice M.R. Shah and B.V. Nagaratna, how their conclusion is invalid or their conclusion is faulty. So the first reason writer says that if we carefully read the language of Article 254 of the Indian Constitution, which shows that the repugnancy under this article relates to the state law and a substantive law which is made by the parliament. So if we have a careful reading of this article, then the UGC regulations are not law as per the language of the, or for the consideration of the Article 254. It impliedly excludes regulations, rules, etc. So rules and regulations which are made by a subordinate authority. Now UGC here is a subordinate authority according to the writer, and in this case the UGC, whereas the substantive law is made by the superior authority, namely. So let us now talk about the language of Article 254. So according to Article 254 of the Indian Constitution, the law which is made by the legislature of such state shall, if it has been reserved for the consideration of the President, here the term law denotes the bill which is passed by the legislature and reserved for the consideration of the President, which does not contain rules, regulations, etc. So the identical words such as any provision of a law which is made by Parliament are used in this article in the context of the Parliament. Now what the writer wants to say, that if we carefully read the language of Article 254 of the Indian Constitution, then it has talked of the law which is made by the Parliament and not that of any subordinate body such as UGC. Alright, so according to this writer, holding that a rules and regulations which are formed by the subordinate body like UGC would stand superordinate to the state legislature or the state law. So therefore, it can only mean that the substantive law and not the subordinate law. Therefore, it becomes clear that the issue or the core issue of the repugnancy which has been highlighted by the Supreme Court is between that of the Universities Act and the act passed by the Parliament, and not that of the regulations of the UGC. So this is the first reason that the writer has given. Now we speak of the second reason that writer talks about, that why the conclusion which is given by the judgment of the Supreme Court or the bench which is headed by the justice, that the rules and regulations which are made by a subordinate authority such as UGC, though it is laid in the Parliament, but it does not go through the same process as a law which is made by the Parliament or the state legislature goes through. So any law which is passed by the Parliament or the state legislature goes through a certain process of scrutiny, debate, discussions, etc. But the rules and regulations which are passed by the UGC has not undergone any process of scrutiny, debate and discussion. So therefore, the normal procedure under which a law is passed, the rules and regulations are not of UGC are not passed in the same manner. So the rules and regulations, they have an inferior status when we compare it with the State Act. So the Constitution cannot be assumed to equate the Act with the rules. So this is what the writer has to say. Now we speak of the third reason. The third reason is the Constitution does not in general terms define, so this is define the term law. So therefore, the inclusive definition of law given in Article 13, which is applicable only to that article, it has no application to other article, which means the term law does not include the rules, regulation, etc. for the purpose of Article 254. So like I have explained to you earlier, that according to the according to the writer, the Article 13 of the Indian Constitution contains the definition, or it defines the law for the purpose of that article and not for the Article 254. And also the writer says that the definition of the law which is given in Article 13 of the Indian Constitution does not include rules and regulations passed by the subordinate bodies such as UGC. The fourth reason that the writer has to say is that the subordinate authority of the Union overriding a law which is made by the state legislature will amount violation of the federal principle and a negation of the concurrent legislative power which is granted to the state by the Constitution. Finally, The UGC regulation on the appointment of the vice chancellors, they are outside the scope of the main provision of the UGC Act, and as none of its provision refers to the appointment of the vice chancellor. So this is the fourth reason which the writer has to say, that regulations formed by the UGC body, they are not independent legislations. So according to the writer, the fourth reason that the writer has given is that the regulations which are formed by the UGC, they are not the independent legislation. That means they should be within the scope of the parent act, and otherwise they will ultra vires the act. So a pursuit of section 26 of the UGC Act, which empowers the UGC to make regulations, would show that the appointment of a vice chancellor is not a matter on which the UGC can make regulation. All right, so according to the section 26 of the UGC Act, which has empowered UGC to make regulation, it would show that the appointment of a vice chancellor is not a matter on which the UGC can make regulations. So this is the fourth reason that the writer is saying that the why. So we are discussing the writer's view that why the conclusion given by the judgment of the Supreme Court, or the core issue which has been raised by the Supreme Court, is faulty. So the UGC's legal authority to make a mandatory regulation on the appointment of vice chancellors of the state university, it would need a re-examination urgently. The Supreme Court did not, in the case above, analyze the concept of repugnancy before holding that the state university law are repugnant to the UGC regulation, and therefore the appointment are void ab initio. So I have already described the meaning of ab initio. That means since the beginning, the Supreme Court did not, in the case above, analyze the concept of repugnancy. So Article 254 needs to be analyzed in depth before reaching such conclusion, such as the analysis would make it such an analysis, the analysis which has been presented by the writer in this article, it would make it clear that a state law can be repugnant only to the Central Act, not the regulations and rules made under the UGC or by the UGC. So since the issue is bound with the rights of the state to manage the university education, therefore it would need a more serious attention. So if I conclude this editorial, or if I conclude this article, then the first point that the writer has raised, that a subordinate authority such as UGC cannot be held superordinate to the state legislature. All right, the second point which the writer says, that the law, rules and regulation for the purpose of Article 13 does not include the rules and regulations made by a subordinate body such as UGC. All right, and the third point which the writer has raised is the federal issue between the two federal units, that the center and the state. What the writer wants to say, that if we do not look into this matter with serious attention, then we are going to have a federal issue, because education is in concurrent list. Education is in concurrent list. All right, that means both the union and the state government has the right to make regulations and law on education, and according to the writer, a subordinate body such as UGC shall not be or cannot be superordinate to the state law. The Supreme Court held that S. Satyapal Reddy versus the government of Andhra Pradesh in the year 1994, that the court has to make every attempt to reconcile the provisions of the apparently conflicting laws, and the court would endeavor to give a harmonious construction. So this principle of harmonious construction means that the Supreme Court is of the responsibility that there should be a balance between the state law and the union law. The proper test, according to the writer, would be whether effect can be given to the provisions of both the laws or whether both the laws can stand together. When this is done in most of the cases, there would be no need to strike down a state law on the ground of repugnancy. So this is what the writer has to say with respect to quashing the appointment of the vice chancellors of the university by the Supreme Court. So I hope that you've discussed, you've understood this editorial well, and you'll be able to write and address this question. If in the GS General Studies paper 2 question related with the governor, with the power of the vice chancellor, or the federal issue that time to time arise between the union and the state government shall be addressed, because we have in our General Studies paper 2 syllabus, we have one topic, the federal issue. The federal issue. So this needs to be understood in the light of this topic. So thank you so much for watching Tarunayas. If you need the PDF of this topic, you can go to our Telegram channel. Have a nice day.